Estimados amigos del programa Vértice, bienvenidos una vez más a este programa que lo dirige el programa de la Maestría en Derecho de la Empresa de la Pontificia Universidad Católica del Perú. Les habla el profesor Edison Tabra, profesor de esta maestría. En esta ocasión nos sentimos muy entusiasmados por contar con la presencia de un distinguido profesor de la Fundación Getulio Vargas, el profesor Luca Belli. El profesor Luca Belli es doctor y también profesor en Gobierno de Internet y Regulación en la Fundación Getulio Vargas. También está adscrito como un investigador al Centro de Derecho Público de la Universidad de París II. También antes de unirse a la Fundación Getulio Vargas, el profesor Luca colaboró en el Consejo de Europa para el Gobierno de Internet y también en lo que es la red de neutralidad y es un experto en lo que es los temas de Internet y sociedad. El profesor Luca tiene más de 30 investigaciones, todas ellas escritas en inglés, francés, italiano, portugués y español. Es tan vasta su producción que la verdad el tiempo no nos daría para poder mencionar todas. Puedo indicar algunas como del gobierno a la regulación Internet. Luego también tiene otra obra llamada El compendio de la neutralidad en la red. También regulaciones y plataforma en Internet, cómo las plataformas tienen que ser reguladas. También tiene otra obra titulada Regulaciones y Gobierno de Internet en América Latina. Y en fin, tiene muchísimas obras que están publicadas en las más distinguidas revistas de Europa y de América Latina. Bueno, para nosotros es un enorme placer tener su presencia, el profesor Luca, y le damos la bienvenida. Y profesor Luca, welcome to the Vértice program. Please feel free to give your first words to the audience.
Thank you very much for the invitation. As I was mentioning before, mi español es muy básico, so I will speak in English to be more effective so that you can enjoy more my presentations and this conversation. Professor Edison, thank you very much for this kind invitation. It's a great pleasure to be here with you guys. Let me know if you want me to start by providing an overview of what are the tools that can be used to govern platforms and how digital platforms can be regulated, or if you want to ask any other introductory question, as you prefer. You're in charge.
Thank you, Professor Luca. Well, maybe a first question. We were talking before this interview. It's about digital platforms. We were very curious to know about what are the tools for governing digital platforms around the world, around America Latina?
Yes, so to understand the governance of the internet ecosystem in general and of online platforms in particular, it's very important to realize that the traditional tools for regulation that lawyers are used to deal with, like law, decision, regulatory tools elaborated by public administrations, are only a part of the more complex regulatory ecosystems and sets of regulatory tools. So what do I mean when I say that the traditional tools are only a part of the regulatory tool that we have at disposal when we consider the regulation of platforms? Well, of course, you may have very important laws that regulate specific sectors or specific issues. For instance, there are more than 130 countries in the world that have already adopted data protection regulation in order to regulate in a solid, sustainable way the protection of personal data. But of course, you may have also core decisions that are very important. For instance, only a couple of weeks ago, there was a major decision about the right to be forgotten in the EU. But those are only part of the bigger picture. Actually, the most interesting tools to analyze are tools of self-regulation, or a sort of private regulation that is implemented, is designed and implemented directly by those that usually would be considered the regulated, but actually ends up being the regulator. So if you consider a corporation, usually a corporation is the regulated entity, right? But if we consider the digital environment, we see that actually our behavior of a user of a digital platform are much more regulated by the contractual regulation defined by the digital platform, the terms of service, or the algorithms, the technical structure of the digital platform. So what I can say, for instance, on Facebook is much more regulated by Facebook community guidelines or terms of service than by the Constitution of Brazil. The way in which I receive information is on a social network is organized by the algorithm of the specific platform, much more than any court decision or piece of legislation. So to understand how people's interactions are regulated online, in particular in platform, one really needs to consider the regulatory value of these other non-traditional tools, the terms of service, its contractual regulation, and all the set of technical tools like algorithms that shape the environment in which people can interact. And by shaping the architecture of the environment, also direct the behaviors of the users.
Okay, that sounds interesting. So, according to your point of view, what are the main legal challenges that actually these kind of digital platforms are presenting actually in case of Latin American or maybe in the United States or in Europe?
Well, there are a lot of different challenges, of course. It's obviously one of the main challenges, one of the most discussed challenges is how platforms are collecting and processing personal data. Personal data are usually considered the oil of the 21st century, although this metaphor may not be so precise, gives you a good idea of how valuable personal data have become. And actually, if you check the list of the most valuable public traded corporations in the world, 7 out of 10 are tech companies that collect and process data and organize data. The great value, what I'm also mentioning when I speak about the regulatory power, the regulatory value of the technical tools that structure the platforms, is precisely the fact that they are able to regulate how do you exchange information, but also how do you do business. And this is what in the 90s, at the end of the 80s actually, a political scientist, Susan Strange, defined as structural power. It is a different kind of power. It is not to impose one's will, but it is to shape how other people, how other companies can interact, can do business, can communicate information, can share information. So given the importance of how personal data are collected and processed lately, the most intense legislative production in terms of internet policy lately has been with regard to data protection. For instance, Brazil has just adopted 1 year ago a new general law on data protection that will enter in force next year. In the EU, the new data protection regulation, GDPR, the General Data Protection Regulation, entered in force 1 year ago. So we have seen a great intensification of legislative production with regard to data protection, but of course, without the cooperation of digital platforms, it's very difficult to concretely implement the law. So actually, even if for other very debated issues, for instance, the fight to fake news, if you do not involve the platform in the implementation of the tools that may be designed by the public authorities, it's very difficult to have an effective and efficient reply to the spread of misinformation or even to incitement to hatred, which is lately quite widespread in social networks, for instance.
Yes, that's nice. So maybe when we talk about this kind of topic related to digital platforms, maybe we can relate it to multinational companies.
Mm-hmm.
But how about in the case of small and medium companies? How they can be related or with the case of digital platforms, or maybe how they create problems in this case?
Well, what is very interesting is to consider that frequently when internet users associations, civil society advocates, or even some academics call for regulation in order to create rules that can frame in an efficient way how platforms behave, we frequently forget that the platforms, online platforms, are not only major tech companies. So if we shape and elaborate regulation only having in mind big tech companies like Google and Facebook, we will end up only having Google and Facebook in the digital ecosystems because they will be the only one able to comply with the rules, right? So what is very important is to have a progressive approach. So it's very hard to believe that very burdensome regulation may not stifle innovation. At the same time, when for big tech companies that consolidate, aggregate information, and not only information, but also the power that comes with the consolidation of the world's personal data, the world's information, then if you have these major tech companies, you need to define precisely some limits to that power, to some checks and balances, so that the power of major dominant player is somehow curtailed, limited. On the other hand, when you have startups, you may not require them to undertake the same level of compliance, the same kind of obligations that you have with regard to big tech companies. An example, for instance, of this is the German law with regard to fake news, the NetzDG, that although has been criticized for a variety of reasons, has in its very first article a distinction between big tech and startups, saying that the law applies only to platforms that have more than 2 million users. So actually that is very important because, of course, it's a political choice. Why 2 million, not 5 million or 50 million? It's a political choice. But you have somehow to have a sustainable regulatory environment to create a distinction between the newcomers the startups that still have to flourish and to expand their business, and those who are already consolidated and therefore have to bear the greatest responsibility.
Nice. So I have another question. Is about the case of how are the digital platforms privatize regulation and police functions. Maybe it's related in the case of the rule of the states, no? When how they can be able to regulate or maybe put the laws in order to control the function of the platforms in this case.
So what is very interesting to reply to your question is to take a little step backward and to understand that the digital platform themselves are already behaving as some sort of private regulators. They are actually consolidating quasi-juridical, quasi-executive, and quasi-normative powers. Why am I saying that? When platforms define unilaterally their terms of service, because when the terms of service that each of us accept by clicking, and of course everyone has read carefully, those terms of service are unilaterally defined by the platform and can be modified unilaterally by the platform. It's a little bit like the law of a specific country, but rather than applying to a country, it applies to a platform. So the frontier are not physical frontier, but are electronic frontier shaped by the structure, the electronic structure of the platform. So within that platform, the law is primarily the contract unilaterally defined by the platform. And that same contract, those provisions are implemented not because some sort of public bodies implements the regulation within the platform, but because the platform itself implements, for instance, using specific algorithms, or removing a specific kind of content. If you try, for instance, in many social networks to share copyrighted material or to share any kind of child pornography, that kind of material is usually automatically filtered and removed and taken down, because platforms already can implement their own regulation through technical means. And last but not least, they can also judge with alternative dispute resolution system. They can create parallel juridical system, private juridical systems with the alternative dispute resolution, where the law, the regulation that is implemented to solve the disputes is the private regulation defined by the platform according to the private criteria defined by the platform. So, for instance, if you flag an abusive content in your favorite social network, then you will enter into a alternative dispute resolution system where you will have to argue why the content has to be taken down, and the person that posted the content may frequently have the possibility to rebuttal your claims and to argue that no, the content has to stay on. And at the end of the day, the final call is the platform call according to the platform rules. So given this regulatory function of the platforms, many public bodies are delegating to platform themselves the task of regulating specific conflict of rights. And for instance, the right to be forgotten case that I was mentioning before, it's a very good example of this, because actually it's the highest court in the EU, the Court of Justice of the European Union, that in 2014 with the Costeja Gonzalez case, the Google Spain case, actually delegated to online search engines the task to delist those information that were considered inadequate, no longer relevant, or excessive or irrelevant. And therefore, it was up to a private platform, a search engine, to evaluate when those information that were provided as a result of the search were no longer relevant or excessive or irrelevant, and to delist the results. So it was actually a court delegating to a private platform what is a quintessentially public function, the function of balancing freedom of information on the one hand and protection to privacy on the other hand. And that was directly delegated to search engine. So it's a sort of hybrid governance system. Also has been argued by other scholars. For instance, Radu and Chenu argued this, and this is actually something that is not only, well, it's typical to the European system, but has been considered also by a variety of other legislators around the world.
Okay. So in the case of right to be forgotten, have you detected another constitutional rights or simply rights that can be affected by the work of these digital platforms, and you maybe recommend to be treated or saluted by the public states?
Well, of course, the two main fundamental rights at stake here are, on the one hand, the freedom of information of the general public that has the freedom to look for information online, but on the other hand, also the right to privacy and also to data protection. Let's do not forget that in Europe, those two rights are two different rights: data protection and privacy, and both are protected as fundamental. In other frameworks, data protection is more under the umbrella of privacy, but in Europe, so you have on the one hand legitimate claims of freedom of information, on the other hand legitimate claims of data protection and privacy. But of course you also have somehow a right to due process that enters into the picture, because as I was mentioning before, if you delegate the function to regulate between freedom of information and data protection to a private entity, well, it means that you are actually giving to a private entity that is not a public body, is not a court, has not the employees of any search engine do not receive the same legal training, or the same, they do not have the same ethical standards that judges and their clerks are supposed to have. So, and the way in which the various platforms also can implement the, let's say, for instance, a basic form to request the delisting of a specific piece of information may vary tremendously from one platform to the other. So all those elements impact enormously how people can actually enjoy their right to be forgotten. So the way in which this has been solved in the EU, for instance, is to allow data subjects that request to delist information also to have a right to appeal the decision of the private entity of the search engine to the National Data Protection Authority. So in order to guarantee that the rule of law is respected, any decision that a data subject wants to appeal can be appealed to the Data Protection Authority. Another very important point that has been stressed only a couple of weeks ago with regard to the right to be forgotten, another landmark decision was taken by the European Court of Justice only 2 weeks ago, on the 24th of September, actually. It was the decision to only oblige search engine to delist within the European jurisdiction. So there was another case pending since 2015 that was seeing the French Data Protection Authority, the CNIL, against Google. And the dispute was about whether the Google had to delist in all its versions of the Google search engine the results, or only in the versions that are accessible in Europe. Of course, Google was claiming that a European judgment or a French judgment was binding only in a European or French jurisdiction. On the other hand, the CNIL, the Data Protection Authority in France, was arguing that it was not really efficient to and effective to only block, delist these results in Europe, because it was easy to bypass this delisting by simply using a different domain name rather than google.fr, for instance, google.com. So the landmark decision of the European Court of Justice only 2 weeks ago was indeed to state that, in fact, Google only has to delist within Europe. The delisting does not apply globally, because this would be actually an extraterritorial effect of the European jurisdiction, and they may also create a very tricky precedent, because, for instance, authoritarian countries around the world may then claim that Google has to delist anything globally, and therefore this would have a quite nefarious impact on people's right to freedom of information.
So in this line of conversation, you mentioned about the practice of corporates. So in relation with the use of this kind of platforms. So according to your point of view, what should be the most appropriate corporate practice that companies must put in practice in order to prevent this kind of violation of privacy of people, or maybe to another constitutional rights?
Well, first of all, as any lawyer would suggest, first of all, check what is the applicable law. So, of course, the first step of due diligence is to diligently check if there is any specific regulation that applies to your activity, of course. Then, of course, it's also very important, as I was mentioning before, with regard to the German law on fake news, the NetzDG, to check if there is any exemption, because in some countries you may have a kind of regulation that applies to enterprises and businesses that have a certain size, but not to everyone. So if you're a startup, you may not, you may well be exempted from any kind of regulation. On the other hand, actually, it's important to understand that businesses have really a vital function in the digital ecosystem, because they are the main stakeholder that produces innovation, at least one of the main stakeholders producing innovation. So they have, on the one hand, this constant incentive to produce creative work, to produce new innovations, new solutions. But on the other hand, there are responsibilities that, of course, they have to consider and respect. And of course, the first step of due diligence is to understand what are those responsibilities and try to comply as much as possible with the law. I would say that one of the best suggestions is, in the countries where there are, for instance, data protection authorities, one of the best approaches is to directly contact the data protection authority, for instance, to seek for advice. That is one of the fundamental functions of the regulator, has to be to educate rather than repress. So establishing a dialogue with the authority in order to seek for advice is the best way to avoid to enter into some criminal or conduct, or any kind of behavior that may trigger any kind of liability. So yes, the first step would be to have a good lawyer that checks what is the applicable law. The second one would be to identify regulators that may be helpful in understanding what are the specific obligations, and then start to do your business in the most creative way, and of course trying to respect any kind of existing regulation.
Will you suggest to impose some extra obligatories or maybe some extra rules for example, directors or most of the directors of a company, for example, for Google, where maybe we can contemplate to impose extra rules to board of directors in case that they have to check or maybe make some like of surveillance that the platform of the business runs well. I don't know if it's correct, or maybe just leave to the CEO of the personnel of the CEO to do this job.
You know, I mean, in the majority of countries in the world, directors in a board of directors or the CEO, they have a fiduciary obligation to maximize the profits of the corporation and not to do the best thing for humanity, right? That is the reason why you need regulation, and that is the reason why sometimes some hard choices have to be done by either by regulators or by courts or by governments, because of course you can, and that is also the reason why it's a little bit tricky to delegate regulatory functions to private entities, because their interest and it is normal of any business enterprise, the interest is to minimize costs and maximize profits. So if we come back to the right to be forgotten example, when you have to implement a solution that allows you to ponder between freedom of information and protection of privacy or data protection, you will implement the solution that costs the least and that allows you to handle the biggest number of requests the most fastly possible, but not the solution that is the most just or fair, because your interest is to minimize costs, maximize profit, not to have the best possible solution to fundamental rights, because that is not your task. The task of the business is not to regulate fundamental rights. It's the task of the court to regulate fundamental rights. So I'm not sure the right path is to create new obligations to ponder fundamental rights for boards of directors or for top executives. I think the most suitable and sustainable approach is to have clearer rules that are up to date and then consider the current state of play of the digital environment, defined by the public bodies, by regulators, by the government. And probably even better would be to have maybe principles and clear strategic objectives defined by the public authorities, and then implemented. Leave the implementation to the private sector, so that the most efficient solutions are elaborated, while keeping a control on those solutions, reviewing them, and if they don't work, if they are not fair, if they are not just, then there will be public regulation. But in this case, you have the general principles, objectives, a sort of co-regulatory approach, where you have general principles and objective defined by the public bodies in the public interest, solutions, the most efficient solutions implemented by the private sector, but then the private sector has a pressure also not only to implement the most efficient, but also the most just solution, because if they do not do so, there will be regulation.
That's very interesting. So as we are finishing this interesting and marvelous interview, so what's your perspective your personal views about the situation in Latin America for the next 20 years or 30 years in the camp of, or the side of platforms. What's your personal view in this case, in contrast to Europe's or United States reality?
Well, let's say that, well, I don't have, of course, an exhaustive reply to that. Otherwise, I would be already a billionaire with a crystal ball, providing solutions to the highest bidder. But let's say that what I see is that Latin America is facing very similar challenges to Europe or United States, but actually, I think the biggest problem is try to elaborate and find different solutions, not copy and paste what has been done in Europe or the United States, but of course consider the other countries' experience, but try to not just to adapt them and do a Latin American version, but use them as a useful experience, examples to be considered, but then try also different things. Actually, the very, asking this, you remind me of really the very reason why we have here also created another project called Cyber BRICS that explores digital policies in the BRICS countries, Brazil, Russia, India, China, and South Africa. And the very reason of that project is precisely to try to map and understand the kind of choices that are made in those countries that are not traditional, not what we could consider a traditional source of wisdom, not because they do not have incredible wisdom, because they have, but simply because we are used to consider Europe or the United States as the traditional source of wisdom. So what my suggestion would be to dig a little bit more into the wisdom that exists in different countries that are not the usual example of development and can be elaborated further, can be considered in different perspectives, so that different solutions that may not be only as suitable as the ones that have been developed so far in Europe or United States, but maybe even better, actually much better, because they consider the local culture, the local juridical tradition, and are not only a copy and paste of what already exists elsewhere, but that may be totally inefficient in Latin America.
I was thinking to ask about that cyber project,
yes.
Cyber BRICS project.
Yes.
But, well, making some extension of the question, is it possible to extend the work that you are doing in Cyber BRICS project for case of countries related to Brazil, India, Russia, to the rest of Latin America countries, or maybe to include another countries, because this topic related to platforms are very interesting, and I think it's very interesting to include more actors, even companies, or even investors, or even governments.
Well, let's say that let's first make a distinction, because actually my work on platforms is somehow separated to the work on digital policies in the BRICS. Those are two different avenues of research that, of course, they have intersections. But of course, the work that we are doing here on digital platforms, or the general analysis of digital policies in the BRICS, of course, it can be replicated elsewhere. Then what is, of course, that is an excellent idea, but as we all know, what really makes the difference is not the excellent idea, but the implementation of the excellent idea. So it would be excellent to replicate the analysis we have been doing on digital platforms, as well as the analysis that we are doing on digital policies in the BRICS, to the Latin American context, it's an excellent idea. Of course, it would require a lot of resources and a lot of preparation. So that is maybe an excellent tip for future cooperations. Who knows?
We hope so. We hope so.
Yes, I mean, I really look forward to explore further possibility for cooperation. So yes, let's speak about this in a further conversation. But it's an excellent idea, and so far, there is a lot of research still to be done with regard to digital policies and digital platforms, and it's the most interesting, at least for me, domain of legal research, because you actually have every week a new announcement, a new law, a new technology that can disrupt the research that has been done over the past 3 or 4 or 5 years. So yes, it's very challenging and very interesting, and a lot of things still have to be done. So it's also a very good opportunity for cooperation.
Okay. Well, Professor Luca Belli, it was for us a huge honor to have in the program Vértice. So we hope to have more interviews, interesting interviews with you, because this topic related to digital platforms are really interesting, and there are, as you told us, we need more time to talk about it. So please, maybe you have some final words or feelings to focus to our audience of the Pontifical Catholic University of Peru.
Actually, I would invite you, I can send you a list of publications and papers that maybe you can share, so that people that are interested in knowing more, both in internet governance and regulations in Latin America, digital platforms, cyber bricks, can find easily. And then, of course, I invite you, Edison, to enter in contact again, so that we can discuss further any kind of future cooperation. And of course, I will be more than happy to come back and speak with you guys and have further conversation on these topics that are extremely interesting for me. And there is always a lot of new information to be shared and discussed. So please do not hesitate to invite me again. It will be a pleasure to come again.
Bueno, estimados amigos del programa Vértice de la Pontificia Universidad Católica del Perú, del programa de la Maestría en Derecho de la Empresa, estuvo con nosotros el profesor de la Escuela de Derecho de la Fundación Getulio Vargas de Brasil, el profesor Luca Belli, a quien tuvimos en este programa. Conmigo será hasta otra oportunidad. Muchas gracias.